Hello friends, welcome to IAS at Speed of Light, and we're starting with the part 2 of Indian polity conceptual. In the previous lecture, we have studied about the salient features of the constitution. We understood the basic terms related with the polity, like the federation, what federation means, what type of Indian federation it is, and the parliamentary form of government, and so on and so forth. Now, from today, we are going to start with the main constitutional part, and when we open the constitution, the first thing which we get is the preamble of the constitution. This particular part, the preamble of the constitution, it was added in the last by the Constituent Assembly after finishing the whole of the constitution. The reason for this was the constituent framers, they wanted to give a glimpse of whatever they have given in the constitution, or whatever constitution has derived the objectives for the people of the country. So let us go point by point for preamble of the Constitution. It refers to the introduction or preface of the Constitution. It gives the introduction of the whole of the Constitution and preface of the Constitution like an index of a book. It is also known as the identity card of the Constitution, which gives the essence or the summary of the objectives which are enshrined in the Constitution. It was added to the Constitution at the last after completing whole of the Constitution, based on the objective resolutions by Jawaharlal Nehru in the Constituent Assembly. So these preamble, these are based on the objective resolutions which are passed by the Jawaharlal Nehru and which was also adopted by the Constituent Assembly. This constitution, it has been amended only once in 1976 by the 42nd Constitutional Amendment Act, and these Constitutional Amendment Acts becomes important to remember for examinations. Some important Constitutional Amendment Acts, particularly for state services, these questions are asked very directly, like what this Constitutional Amendment Act did the change in the Constitution of India. Using this Constitutional Amendment Act, Government of India added three new words in the constituent in the preamble part of the Constitution, which was socialist, secular, and integrity. That we will see now. Let us go to the main test of preamble, and I hope you are having the book PM Bakshi with you. So PM Bakshi, we will start with page number 1 and the preamble, and we'll read the preamble. In preamble, it says, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and secure to all its citizens justice, which includes social, economic, and political justice, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, the 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution." So, the first paragraph, the word socialist and secular, these two words were added by the 42nd Constitutional Amendment Act. And again, if you see, the unity and integrity of the nation, in the paragraph of fraternity, the part integrity was added by the 42nd Constitutional Amendment Act. Now let us analyze this whole test. This whole test gives us four information. If we see, if we read the first line, "We the people of India having solemnly resolved to constitute India." So first information what this preamble gives us is about the Constitution. What is the source of authority of the Constitution? So it is "We the people of India." So the Constitution derives its authority from the people of India. This is the first information what preamble gives us from its first sentence. Now second sentence it says, "To constitute India into a sovereign, socialist, secular, democratic republic." And all these words are the characteristics of a nature of the polity of a state. So second line, it tells us about the nature of India's state polity. What is India? India is a sovereign country, India is a socialist country, India is a secular country, India is a democratic country, and India is a republic country. So these are the characteristic features what preamble says India is. Let us see one by one the brief meaning of each of these words. The first one, sovereign. Sovereign, it means an independent country. It says India is an independent country and there is no authority above India. And what it means is India is free to manage its external and internal affairs. So this question came up in Constituent Assembly when India became the part of Commonwealth nations with Britain as the head of the Commonwealth nations. This question came up whether this union with the or this association with the Commonwealth nation, whether it is going to affect the sovereignty of the country in any way. So Jawaharlal Nehru cleared that particular point in Constituent Assembly, saying being in association with different countries doesn't amount or doesn't affect the sovereignty of India. India will remain a free and independent country, and it is not the dominion of any other country. So sovereign, it means India is an independent nation and will manage its external and internal affairs. Now, second word, socialist, we have seen it was added by the 42nd Constitution Amendment Act. Socialist, though it was added in the year of 42nd Constitutional Amendment Act, but the socialist principles are there in the Constitution right from the starting. When we will study the part 4 of the Constitution, that is the directive principles of state policy, we'll see how socialist principles have been incorporated in the Constitution of India. And being socialist, there are three aspects to that. The first one are the capitalist. The second are the socialist. The third one are the communist. Being capitalist, as we have read in the economics as well, they want nothing under state. So they say there should be minimum state interference and all the distribution and production of goods under the should be under the private hand. It should be left to the free market based on demand and supply. So nothing under state. While socialists, they are in between the two extremes. Where communists, they say nothing should be under the private control, nothing under private. While socialists say they say the essential commodities or the production and distribution of essential items should be under the state and not under the private. So we are a form of socialist democratic country, and its objectives are to end poverty and inequality. Uh, Third term which comes in preamble after sovereign socialist, India is a secular country, and this word was also added by the 42nd Constitutional Amendment Act. Again, same as socialist, this word was not there in the preamble, but still we see number of articles, particularly fundamental rights, when we'll study article number 25 to 28, which is the right to freedom of religion. It clearly mentions about the secular nature of the Indian state, and this was made explicit in the preamble that India is a secular state, and it means that there should be no state religion, and all religions of the land should get equal status and support from the state. Let's move to the fourth word which comes in preamble about the nature of India's state polity. It is democratic. Democracy, it simply means supreme power is with the people. Now people, they elect their own representatives, and these representatives on the behalf of these people, they run the government and they make laws. So supreme power is with the people. This is what democratic country means. Some of the key features of Indian democratic nature is universal adult franchise, which we saw 18 plus you are eligible to vote. Independence of Election Commission. It is an independent body which has been given a status of constitutional body. No discrimination on certain grounds for contesting of elections. Right, so this is the democratic nature of Indian polity. Now another word which comes in the preamble about the nature of India's state polity, it is the republic. Last class we have seen how Indian parliamentary form of government is different from the British parliamentary form of government in which they follow a monarchical system, which means the head of the state is hereditary, while republic means the head of the state, like the president of India, is always an elected person. Okay, so republic means the head of Indian state is always an elected person. So this is the second information what this preamble gives us. First, it gives the source of authority of the constitution. Second, it gives the nature of India's state polity. The third, it gives what are the objectives of this constitution for the people of India. To secure to all its citizens justice, liberty, equality, and fraternity. Okay, so what are the objectives of constitution for the people of India? So constitution gives justice, which includes social justice. So what social justice means? It means a ban on there should be no discrimination based on the social status of the people, based on their caste, based on their religion, based on their sex. There should be no discrimination among the people. So this is the social justice. Second form of justice is the economic justice. It says there should be no discrimination among the poor and the richest, and the state will try to reduce the inequality between these two classes. And third one, they say it is the political justice, means all have political rights, all have right to vote, and all have equal access, or they have equal opportunity to hold the positions under the state. Right, so this is the justice. Now second is liberty. Liberty is simply means freedom. Freedom, so they say freedom of thought, freedom of expression, freedom of belief, freedom of faith, freedom of worship. So again, these things we will study fundamental rights, which is the right to freedom, right of freedom. Then comes equality. They say equality of status and opportunity. We will see fundamental rights, how these objectives are being met in the constitution. Okay. Equality for the people of India, equality of status, and equality of opportunity. Then comes fraternity. Fraternity means brotherhood, or fraternity means the sense of belongingness. Okay, so this also have been given in fundamental duties 51A. That all people of India, they should try to or they should promote brotherhood and to protect the unity and the integrity of the country of India. The fourth information what this preamble gives us, it is the date of adoption of constitution. It says in our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this constitution. So 26 November 1949 is the date of adoption of constitution. So it is an important fact to remember. So this is, so far it's very easy. We are studying the preamble of the constitution, which is also the index of the constitution, or summary or essence of the constitution. It gives us four information. First, it say that we, the people of India, are the source of authority for this constitution. Second, it gives the different terms related with India's state polity, how constitution wants India to be. It wants India to be a sovereign country, socialist country, secular country, democratic country, republic country. We saw the meaning, brief meaning of each of these words. Then it says it wants a state to follow these things for the citizens of India, like justice, liberty, equality, fraternity. These things should be promoted among the citizens of India. And fourth information, the date of adoption of this constitution. Now one question came before Supreme Court regarding whether the preamble is part of constitution or not. So what it implies is, if it is not a part of constitution, it cannot be amended by using Constitutional Amendment Act. So this question first time came before Supreme Court in Berubari Union case 1960, and Supreme Court opinion that the preamble is not a part of constitution. So if it is not a part of constitution, that means it is not amendable as well. But second judgment, what it gave in the historical benchmark case of Keshwan and Bharti case 1973, it said preamble is a part of constitution. And same judgment it repeated in LIC of India case 1995 that preamble is a part of constitution. Now when preamble is a part of constitution, then Parliament has a power to amend it using Constitutional Amendment Act. In Keshwanand Bharti case, Supreme Court innovated concept of the basic structure of the constitution. So what it said in that judgment that we will study in the fundamental right as well, Parliament has the power to amend the constitution. It can amend any part of the constitution providing that it is not affecting or it is not altering the basic structure of the constitution. Right, so is preamble amendable is the second question, and in Keshwanand Bharti case 1973, Supreme Court stated that the preamble is amendable, but no basic features can be altered. So this is basic features is an important part which we will see when we'll come to the fundamental rights and that particular article. So this is all about preamble which we need to know. Now we come to the part 1 of Indian Constitution, and that is the Union and its territories. So we started with the preamble, the introduction to the Constitution, and then we come to part 1, which is the Union and its territories. Let us again open P.N. Bakshi book and the part 1 and article number 1. Let us read the article. Article number 1, it says name and territory of the Union. First it says India, that is Bharat, shall be a union of states. Second, the states and territories thereof shall be specified in the first schedule. Third, the territory of India shall comprise of the territories of the states, the union territories specified in the first schedule, and such other territories as may be acquired. So now if we see article number 1, it gives us 4 informations. The first one is, it is giving us the name of the country, and which is India and Bharat. So we have 2 names for India, that is 2 names for our country, that is India and Bharat. The second information what it gives is, India, that is Bharat, shall be the union of states. This thing we discussed, we touched upon in the previous lecture as well, that India is not the federation of a state. India is a union of states. So this, it is mentioning in article 1, part 1. So India is a union of states and not the federation of a state. Why? Because Indian federation is not a result of agreement among the states, and states have no power to cede from the federation. This thing we discussed in the federation part as well. So this is the second information what this article is giving us. Now the third information what it gives is, the state and the territories thereof shall be specified in the first schedule. So it says there has to be first schedule, the schedule number 1 or the appendix of the constitution. These 12 schedules, we call 12 appendices also for the articles. So list of the states and union territories are mentioned in the first schedule of the constitution. So first schedule, it contains the name of the states and union territories. These schedules, and remembering which schedules contains what, it is very important for state services and for UPSC, and every time mostly you will find questions being directly asked on these schedules. So these things we have covered in mnemonics as well. Take help of mnemonics as much as possible in these subjects, because the conceptual part is not so difficult to understand, but to remember such information, such random informations, it is a tedious process. So names of states and union territories in first schedule and union territories. Now fourth information what it is saying is, the territory of India shall comprise of the territories of the states, the union territories specified in the first schedule, and such other territories as may be acquired in futures. So now here if we see the territories of India, this particular word, it is a broader word if you compare it with the union of states. So union of states, it doesn't include union territories in it. While the territories of India, it has the territories of all the states plus the territories of union territories, right? And the territories which may be acquired in future. So this is about the article number 1. the information what it is giving. Let us move to article number 2, Open PM Bakshi. It is page number 8. It says the admission or establishment of new states. So keyword here is it is about the new states. Admission of new states. It says Parliament may by law admit into the Union or establish new states on such terms and conditions as it thinks fit. So this article is pretty simple. It says it talks about the states which are not the part of the Union of India presently, and one new state they are entering into the Union. So Parliament may by simple majority can admit or establish new states. So keyword is simple majority is required. There is no major majority, special majority which Parliament or the government has to prove in the Parliament for the admission of new states in the Union of India. So it talks about the states which are not the part of Union of India presently. While now if we go to article number 3, let us read the article number 3, page number 8, PM Bakshi. Formation of new states, alteration of areas, boundaries, or name of the existing states. So this article now it is talking about the states which are already there in the Union of India. Okay, and now this article is talking about the deformation of these states which are being done by the Parliament or which can be done by the Parliament. Let us read this article. Parliament may by law form a new state by a separation of territory from any state. So one territory you are detaching from one state, or by uniting two or more states getting united, or parts of states by uniting any territory to a part of state. B. Increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state. So all these things can be done by the Parliament, okay? But now how it will be done? There are certain conditions to fulfill, which is there in the next paragraph. Let us go to the screen and let us see. So article number 3, it talks about the internal readjustment of states which are already in existence of in the Union of India. So unlike Article 2, which is talking about the admission of new states into the Union of India, Article 3 is talking about the states which are already there in the Union of India. But there are certain conditions now how this procedure has to take place in Parliament. First point is it can be introduced in the Parliament only in the Parliament and not in state legislatures. An important point, suppose now if Madhya Pradesh want to change the name of the state, so this bill cannot be introduced in the state legislature, but it has to be introduced only in the Parliament. Second point, this bill before introduction, recommendation of President is important. So this bill can be introduced only on the recommendation of President. And third point is when this president will give the recommendation, before that he has to refer this particular bill to the state legislature, that respective state legislature, for their views within a specified time. Okay, so now what is the sequence? First, bill president has to give recommendation, and before recommendation, president will give it to the state legislature for the views, and he will give certain time to the state legislature to give their view. And if state legislature gives its views within that specific time also, president and parliament is not bound by the views of that state legislature. So even if a state legislature gave its views in a specified time, parliament or president is not bound by the legislature views. So that is how India is correctly described as an indestructible union. Union cannot be destructible of destructible state. State can be destructible by parliament action. Okay. Now here if the state says no, we don't want to change the name of our state, or we don't want to change the area of our state, parliament is not bound by the views of state legislature. Okay, so this is Article 3. Let us read it from the paragraph what has been given in Article 3 PM Bakshi. Provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President. So recommendation of President is required for the introduction of bill in Parliament. And unless where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing their views. Okay, so now President, before recommendation, he has to refer the bill to the state legislature. Okay, so this was about the article number 3. Let's move to article number 4. Article number 4 says laws made under Article 20 to provide for the amendment of the first and the fourth schedules and supplemental, incidental and consequential matters. Article number 4 is simply means is if I'm changing any name or if I'm changing the states and the union territories. Schedule 1 we have seen it contains the names of unions and union territories and states. So if any amendment of this Article 1 and 2, it will also lead to the amendment of Schedule 1 because you have to change the names here, change the names of the states and union territories. And Schedule 4. Schedule 4, it contains the seats or the provision for the seats of each state for Rajya Sabha. And we have seen in last lecture as well, the population is the basis to decide which state will represent how many seats in Rajya Sabha. Now, if suppose I'm increasing or decreasing the area of the state, it will also affect the population. So, when the population is going to change for the state, its corresponding seats in Rajya Sabha will also change. So, Schedule 4, which is the representation in Rajya Sabha for each state, it will also be amended. And this is seats in Rajya Sabha for states. So this is very straightforward article. It says amendment will be required if you change any state, if you deform any state. So Schedule 1 has to be amended and Schedule 4 also has to be amended. Now, when we have seen Article 3, it said the Parliament has the power to diminish the area of the state. Now, this question came before Supreme Court whether this Article number 3, the power of Parliament to diminish the area of the state, does it also confers power on Parliament to cede Indian territory to foreign country? That diminished or that removed part, can it give to a foreign territory? So this particular question came in Berubari Union case. Berubari is a name of place in West Bengal, and it was decided by the government of India this particular part of West Bengal they will give it to the Pakistan. Berubari Union case. So in this case, Supreme Court held that the Parliament cannot cede Indian territory to foreign nation under Article 3, and for this effect, for this purpose, they have to introduce Constitutional Amendment Act. But later in 1969, Supreme Court reversed its decision and it ruled that the boundary settlement does not require constitutional amendment and has to be done by the executive action. So this is about the 4 articles, the part 1 of the Constitution of India, Union and its territories. It says, article number 1, it gave us the information of the Union of India. It is not the Federation of India. The name of the country, India, that is Bharat. What all includes the territories of India. Article number 2 gives the powers to Parliament to admit new states into the Union of India. Article number 3 says Parliament has the power to deform states by their will, even if states are not willing to do that. And Article 4, it's straightforward. If any thing happens with Article 2 and 3, it will also lead to the amendment of Schedule 1 and Schedule 4. The second part of Article 4, what it says is such amendment laws shall be passed by simple majority, that is ordinary legislation and not in Constitutional Amendment Act. So any changes these Article 2 and 3 which are making, and any amendment to first and fourth schedule, it will not be called as a Constitutional Amendment Act and it will be ordinary legislation. Okay. Now, after the independence of the country, the issue of reorganization of states on linguistic basis it gained its voice, and there were many voices which are raised in different parts of the country to form states based on the language criteria. So For that, these are the different sequence of events happened. The first was Government of India formed a Dhar Commission in June 1948, which submitted a report in December 1948, and this commission rejected the formation of states based on language, or states on linguistic basis. Uh, After that, immediately, there was one more committee, JVP committee was formed. J is Jawaharlal Nehru, Vallabhbhai Patel, and Pitabhai Sitaramaiah committee, famously known as JVP committee. December 1948, again it submitted a report in April 1949. This committee also rejected the formation of states based on or based on language. But Government of India was forced to form first linguistic state Andhra Pradesh in 1953. And late same year, one more commission was formed, Faisal Ali Commission, 1953 December. This commission broadly accepted the formation of state based on the cultural homogeneity, but it rejected the formation of one state and one language. Okay, so administrative convenience and development has to be the first two criteria for the formation of a new state, and not the language. Yes, cultural homogeneity and the preservation of that particular culture or language can be sought as the other factors apart from administrative convenience and development. Major criterias. Okay. And finally, it led to the passing of a State Reorganization Act 1956, and with this the State Reorganization Act, we see the formation of 14 states and 6 union territories. So this is all about the part 1 of Indian Constitution. And part 1 of Indian Constitution, it deals with the union and its territories. Part 2 of the Constitution is the citizenship. Part 2 of the Constitution is not very important for government examination. Not many questions, or not questions. Questions are not asked from this particular part, but it's an easy part and we'll cover it later. Now we are moving to the part 3 of Indian Constitution, which is fundamental rights, and which is the most important part in the Indian Constitution if you are appearing for any competitive exam. If you are appearing for state services, and if you think they will ask 10 questions in Indian polity, out of that 6 to 7 questions will be only from fundamental rights and directive principle of state policies. So these two particular parts, fundamental rights and directive principle of state policies, you should mug up with each article number, like which article 17 if they say, you should be able to say it relates to an untouchability. So these things you can take help of the mnemonics, and very important part. So you have to focus each article, you have to go through in detail. So let us start with the fundamental rights. Part 3. When we say rights, we categorize them in 3 parts. The first one is the fundamental right. The second is the constitution rights. The third one are the legal rights. Now, fundamental rights are those rights which are mentioned under the part 3 of Indian Constitution. A very important point to remember. So fundamental rights are those rights which are present in the part 3 of the Constitution. So any right which is outside part 3, it cannot qualify to be a fundamental right. So part 3 Constitution, it is the fundamental right. So how we define fundamental rights? So all rights which are there only in the part 3 of Indian Constitution, they are the fundamental rights. Now outside part 3 also there are certain rights, and those are known as the constitutional rights. These are the constitutional rights because these are a part of the Constitution, but they are not the part 3 of the Constitution. So the rights which are the part of part 3 of Constitution, they qualify as the fundamental rights, while the outside part 3, it is the constitutional right, like right to vote. Right to vote is a constitutional right because it is not present in the part 3 of the constitution. So right to vote is a constitutional right. Now what is the primary major difference between the fundamental rights and constitutional rights? For any violation of fundamental right, we can directly move to the Supreme Court. So Supreme Court is the protector of fundamental rights. While for the constitutional laws, there is no such provision that you will move directly to the Supreme Court under Article 32, which is in itself is a constitutional right, which is in itself is a fundamental right, the right for constitutional remedies, Article number 32, in which any violation for the fundamental right, it can be challenged in Supreme Court. So that is the major difference between the fundamental rights and the constitutional rights. Now, third category is legal rights. Now, part 3, outside part 3, and then it is outside constitution. So those rights which are the statutory right, which are the rights passed by the state legislatures or the Parliament of India, like right to information. This is a legal right, which is not the part of the constitution either, or which is not either the part of the part 3 of the constitution. So this is how we divide the rights in 3 different categories. Now, originally, Constitution gave 7 fundamental rights to all its citizens, but by Constitutional Amendment Act 44th Constitutional Amendment Act, very important Constitutional Amendment Act, it removed the right to property. So presently we have 6 fundamental rights, which are right to equality, which is from Article 14 to 18. So this 14 to 18 combinedly being clubbed together, it gives us a right to equality. Then right to freedom. Right to freedom is from Article 19 to 22. Right against exploitation, which is Article 23 and 24. Right to freedom of religion 25 to 28. Cultural and educational rights 29 to 30. Right to property Article 31 repealed by 44th Constitutional Amendment Act, and 7th right to constitutional remedies, article number 32. You have to remember these all articles by their digits, because many times they give you match the following. For example, they will write freedom, right to freedom, it is article 14 to 18. Then constitutional remedies, they will say article 17. Then you have to match the following. Okay, so that is how the questions are asked in fundamental rights. Now, why fundamental rights are so important for the country, or why this particular portion has been given the most importance in the Constitution of India? It is these fundamental rights ensures equality among all citizens. It ensures dignified life to all citizens. It ensures freedom and liberty to all citizens. It helps in establishment of political democracy in the country. So what it means is, in this, people will be the supreme power, and there will be nothing should be against the rule of law. It established the rule of law, and it limits the power of executives and legislature to take the liberty and dignity of citizens. So it places the limitation on the powers of executives and legislative. They are not allowed to take any actions which will take the liberty and dignity of the citizens. So they are fundamental for the overall development of the citizens. So that is why they are known as the fundamental rights. And they are also required for the overall unity and integrity of the country. Now we come to a very important part of the features and the nature of fundamental rights. Very important to understand. Most of them are negative obligations on the state. Negative obligation, what it means is, it places limitations on the authority and power of the state. What limitation it will put? It will put the limitation that so that state and legislature, they cannot take away these fundamental rights of the people. Okay, so that is how it places negative obligation on the state, while there are certain powers which are, or privileges which are conferred to the citizens also. So this is a positive vibe. Second is most of the rights are enjoyed by such citizens and is the state, while some are against the private individuals also. Some rights we have against the state, against the government bodies, and some rights we also enjoy against the private individual. So from now on, whenever you are going to study any article, you have to make a note. There are four things you have to see carefully. First thing, whether this right is against state only, or whether this right is against the private individuals also. Third thing what you have to see is whether this right is available to citizens only, or D, whether this right is available to foreigners as well. So that is how you start dividing whenever you make notes on any article. You divide it into these four parts, one of these four parts, or the mixture of these four parts. So some rights are against the state, but some rights we also enjoy against the private individuals. These rights are justifiable in the court of law. We have seen that for any aggravation, for any violation of fundamental right, we can directly move to Supreme Court under article number 32, which we will discuss in detail once we will come to that article. These are not absolute in nature and state can put reasonable restrictions on them. So these are not absolute in nature. What it means is for the right of liberty, they cannot be limitless liberty. Okay, and state it has all the powers to put reasonable restrictions on these liberties, seeking the unity and integrity of nation as a first priority. But now whether this is a reasonable restriction or not, these are decided by the Supreme Courts or High Courts. They are not permanent, and why they are not permanent? First is they can be suspended during the time of emergencies. Okay, during emergencies we will study certain fundamental rights get suspended. And second is they are not permanent because they can be amended by the parliament. Again, without affecting the basic features. They can be amended by the parliament using Constitution Amendment Acts, but without affecting the basic features. Sixth point, fundamental rights of the people holding sensitive positions can be suspended or curtailed by the parliament. This again we will see when we will go to that particular article. Most of them are self-executory, while to implement certain laws, parliament has to make laws. Now, if in general we broadly say the features of fundamental rights important, first is they are justifiable, they are not absolute, or permanent. They are formed to protect people from the tyranny of executives and legislatives. Okay, so these are the important features of the fundamental rights. Now let us start with article number 12, which is the first article of part 3. Again, open page number 14 of PM Bakshi, article number 12. So this article, it gives a definition of state. So definition of state, what it means is violation of fundamental rights by whom can be challenged in court. Okay, so we have fundamental rights against whom? What is the definition of state? So in this article, if you can read, in this part, unless the contents otherwise requires, the state includes the government and parliament of India. So first point what it is saying is union government and parliament. Then it says the government and legislature of each of the states. So second it's saying state government and state legislature. Third, it is saying and all local and other authorities within the territory of India under the control of government of India. So local bodies like panchayats, municipalities, Okay, so this is a definition of state, and it gives a broader sense to the word state. It also includes all other local bodies which are there, or certain Supreme Court decisions. It has said even the private bodies or the agencies which are working as an agent of the state also qualifies to be called as a state under the definition of state in Article number 12 of Constitution of India. Let's move to the article number 13 and let us again read it from the PM Bakshi. This is page number 16, article number 13. It says the laws inconsistent with or in derogation of the fundamental rights. So it says that article 13 part 1 it says laws made before the commencement of constitution, it will be, if it is in violation of fundamental rights, they will be declared void. Second, it says, the state shall not make any law which takes away or abridges the rights conferred by this part, and the law made in contravention to this clause shall to the extent of the contravention be void. Now here is a big catch in this article. It says, state cannot make law which will take away the fundamental rights of the people. Now, for example, now if Government of India they make certain law which says the media cannot publish news. So this is a law which takes the fundamental right of freedom of expression from the media. So definitely this violates the fundamental rights and it can be challenged and it will be held as void. But now second case is, what about the Constitutional Amendment Act? Now, using this Constitutional Amendment Act, the Parliament can amend this part itself, okay? And this way also they can take away the fundamental rights of people. So this question came whether this word law, which is used in this article, it means the laws which are made by the legislature, ordinary legislature, or does it includes fundamental Constitutional Amendment Act also? Right? I think I made it clear. Article 13, Part 2 states that the state shall not make any law which takes away the fundamental right of a citizen. Okay, so in relate to that, this word law, this question arises whether the term law which is included in this article part 2 includes just ordinary laws, we saw the example, or it includes the Constitutional Amendment Acts also. So if Constitutional Amendment Acts are not covered under the word law, then the Parliament can amend the fundamental rights itself by amending the Constitution. Okay. Now the Supreme Court in first case Shankari Prasad versus Union of India 1951, it held that the Constitutional Amendment Act is not a law. So it said that now using Constitutional Amendment Act, Parliament can amend fundamental rights. It repeated its judgment in Sajjan Singh versus State of Rajasthan. It again held that Constitutional Amendment Act is not a law and Parliament can use it to amend fundamental rights. It can amend whatever they want. But then came a very historic judgment of Golaknath versus State of Punjab case, in which Supreme Court held that the Constitution has given fundamental rights a transcendental position and it cannot be amended by the state action. Fundamental rights cannot be taken by the state action. Now, for judiciary, Supreme Court held that fundamental rights cannot be amended. Now from here on, we will see a continuous fight between the judiciary and the legislative body of the India. Here judiciary, they said fundamental rights cannot be amended. Now to repel that, Parliament passed the 24th Constitutional Amendment Act. And if you can read the part 4 of Article 13, page number 17, PM Bakshi, it says, nothing as this article shall apply to any amendment of this Constitution made under Article 368. So it said it gave Parliament the power to amend fundamental rights by using Constitutional Amendment Act. And then again came a famous judgment of Keshwanand Bharti case in which Supreme Court held that Supreme Court held that yes, Parliament can amend fundamental rights using constitutional amendment rights. This is the power of Parliament, but basic structure cannot be altered. Okay, the basic structure of the Constitution cannot be altered. Right now, the interesting thing is this particular word, basic structure, has not been explicitly defined by the Supreme Court. Okay, this term basic structure, what it includes in the Constitution, it doesn't split. It is not defined by the Supreme Court explicitly, but in various judgments, the Supreme Court has held some of the things which are the basic structure of the Constitution. So let us list out them. Basic structure. The first one, basic structure, is the supremacy of Constitution. So supremacy of the Constitution is a basic structure as per Supreme Court. The secular characteristics. India is a secular country. Federal structure. Separation of powers. Judicial review. So judicial review in itself is a basic structure of the Constitution, and Parliament cannot say Supreme Court cannot review the laws which are passed by the Parliament for the violation of fundamental rights or for the violation of the Constitution, and obviously to build up a welfare state. Right, so these are some of the things which are included in the basic structure, and the Keshwanand Bharti case, Supreme Court held that yes, Parliament can amend fundamental rights using Constitutional Amendment Act, but whether that is reasonable or whether that is not in violation with the basic structure, that power still remains with judiciary with the power of judicial review. Another important thing about Article 13 is it implicitly mentioned judicial review. This particular word judicial review is not explicitly mentioned anywhere in the Constitution, but this particular article number 13, it implicitly mentioned judicial review. Let us go to the article 14 now, and let us read it from again PM Bakshi, article number 14. This is page number 20. It says equality before law, and from here we are starting right to equality. If you remember, we saw right to equality. It is from article number 14 to article number 18. It says a state shall not deny to any person equality before law or equal protection of laws within the territory of India. Now here the first catch is, first what you should see is, shall not deny to any person. Okay, so any person, this means this particular right is available to both citizens and the foreigners. So available to all persons including foreigners and legal persons. So each article you should categorize it, okay, whether it is available to foreigners or citizens, or whether it is against a state or this is against a private individual also. It gives us two concepts. First, it says equality before law, which is a British concept. And second, it is the equal protection of laws, which is a US concept. Now, what it means is, equality before law is quite self-explanatory. It means that every person, including the foreigners, they shall be treated equally by the law. So there is no one who is above law. There are certain exceptions that we will see. Second is equal protection of law. It means that the law must operate equally among equals. What it means is rolling out certain special schemes only for the poorer people doesn't amount to the violation of Article 14. Okay, because it attempts to bring that poor section nearer to the richer section. So that is to reduce inequality. So law must operate equally among equals. So there are two classes, there can be many classes. So these laws will be separate for those classes. Now, to operationalize equal protection of laws, the categories or these groups what are formed should be homogeneous, and the categories or the groups which are so formed should have a reasonable correlation with the objectives that has to be achieved. This is article number 14, equality before law and equal protection of laws. You should remember these articles with their digits, like equality before law, they will ask, you should be able to say article number 14. There are some exceptions to this equality which we'll study once we'll go to that particular part, which are immunities to President and Governor, Article 361, Article 361A. For members of Parliament, there are certain immunities under Article 105. Members of state legislature, same powers can be conferred, same immunities under Article 194. Certain immunities to ambassadors and diplomats, and for the implementation of directive principles. This is Article 31C. It will require certain discretion that whenever 31C comes, directive principle state policy will be held and fundamental rights will go. So this thing we will discuss when we'll see article number 31C. Now let us come to the article number 15 and let us see what it wants to say. Let us read it from PM Bakshi. So this is page number 31, article number 15. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. What it means is, states shall not discriminate against any citizens on ground only of religion, race, caste, sex, place of birth, or any one of them. So, two things here to note. First thing is, shall not discriminate against any citizen. So first thing what you have to note is available to only citizens and not to foreigners. Right? And second thing is only of religion, race, caste, sex, place of birth, or any one of them. So it is only. Discrimination is not banned for other cases. For example, marks in an exam. Okay, discrimination based on marks is possible. Coming to second part of Article 15, if you can read it, no citizen shall on grounds only of religion, sex, caste, any one of them be subject to any disability, liability, restrictions or conditions with regard to. Okay, there should be no discrimination based on these things for the following. First, A is access to shops, public restaurants, hotel, places of public entertainment. Or B, the use of wells, tanks, bathing ghats, roads, places of public resort maintained wholly or partially out of state funds or dedicated to the use of general public. So this particular right we have available against both state and private individuals. So this is how these first two parts it says discrimination is prohibited. Now if we read third part, it gives certain exceptions to the above mentioned articles, which says nothing in this article shall prevent the state from making any special provisions for women and children. So state is free to make special provisions for women and children, and it will not lead to the violation of article number 15. In this Constitution is conferring power to the Parliament for making the provision for the advancements of socially backward classes, and this was added by the first Constitutional Amendment Act, Article 15 Part 4. Then comes Article 15 Part 5, and this is a very recent amendment, 2005 93rd Constitutional Amendment Act, and it gives for the provision of admissions of socially and educationally backward classes to education institutes. And after this only reservation increase in all IITs and IIMs. Coming to the article number 16 now. Article 16 is one of the most controversial article of Constitution of India, and there has been a lot of fight between the judiciary and the legislative organs of the country over this article. Let us read it. Article number 16, part 1, it says, there shall be equality of opportunity for all citizens in matters relating to the employment or appointment to any office under the state. So, equality of opportunity in matters of public employment. First, it says equality of opportunity for all citizens, not to foreigners, related relating to employment or appointment under the state. This is the first. So all have equal rights and all should have equal opportunity to hold a position under the state. Second part 2, it says no citizen shall on grounds only of religion, race, caste, sex, descent, place of birth, residence or any one of them be ineligible for or discriminated against in respect of any employment or office under the state. So clear, no discrimination on grounds of these things for employment under the state. Article 3 gives the exceptions to the above, which says nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office for what it means is Parliament can prescribe residence as a condition for certain employment for state and union territories. So this is the exception. So this Parliament can prescribe and presently it is applicable only for the state of Andhra Pradesh. Now comes the fourth part. Nothing in this article shall prevent the state from making any provision for the reservation of appointments. Okay, any provision for the reservation of appointments or posts in favor of any backward class of citizens which, in the opinion of the state, is not adequately represented in the services of the state. Okay, so here Parliament has a power to make provisions for the reservations of the backward classes which are not adequately represented in the services. Now let us see what is the history of this particular article. In 1979, a second Backward Classes Commission was framed by the Government of India, which is also famously known as Mandal Commission, and this Mandal Commission suggested for the reservation of 27% for the OBCs based on their population. They said they should have 27% of reservation in government jobs. After 11 years, VP Singh government declared reservation 1990 and Narsinga Rao 1991 he enacted this reservation and added two more elements. First is reservation for the poorer section of OBC and 10% additional reservation for poorer sections of upper classes. So he added, Narsinga Rao government, two sections, economic criteria for reservation. First is reservation for the poorer sections of OBCs. So this reservation will only be applicable to the poorer sections of OBCs. Second is 10% additional reservation for the poorer sections of upper classes also. Now this was challenged in Supreme Court and then came a famous Mandal case 1992. Supreme Court rules the following. The first one, second point, okay, the second point which was a 10% additional reservation, it was rejected by the Supreme Court. It avoided that, okay. Supreme Court rejected 10% additional reservation for the poorer section of higher classes. Second, it stated that the creamy layer among OBC to be excluded. Okay, so this reservation shall not apply to the creamy layer of OBC. This is judiciary. Okay, this is the action taken by judiciary, and this is now legislature what it did, or legislature and executive. Ramnandan Committee, government formed Ramnandan Committee to identify creamy layers, and this committee submitted its report in 1993 and it was accepted by the government. So this was the Supreme Court verdict and this is how legislature fulfilled it. Third, court said the reservation should only be to the initial appointments and no reservations for the promotions. Okay. So judiciary, it said these reservations what you are giving, it will only be conferred to the initial appointments to the services and no reservation should be possible for the promotions. Now you see what legislature did. They passed Constitution Amendment Act 77th and Constitution Amendment Act 85th and it provided for the reservations in promotion and consequential promotions. Let us see 4A and 4B. 4A, let us read 4A. Nothing in this article shall prevent the state from making any provision for reservations in matter of promotion with consecutive seniority to any class or classes or posts in service under the state in favor of scheduled castes and scheduled tribes, which in the opinion of the state are not adequately represented in the services under the state. So they made a Constitution Amendment Act, they changed the fundamental right, they added a new provision in the fundamental rights, and they said by this article, yes, we are eligible to give reservations in the promotions with consecutive seniority. Okay, so they negated this order of Supreme Court by passing this Constitutional Amendment Act. Now we have promotions for only SC and STs, reservations in promotions for only SC and ST and not for OBCs. The fourth judgment what Supreme Court gave, it was a total reservation should not exceed 50%, and in term of that, Government of India what it did, it placed the Tamil Nadu Reservation Act in ninth schedule. So ninth schedule is something which is out of the judicial review. All the acts which are placed in articles which are placed in ninth schedule, these are out of judicial review. But from 2007, Supreme Court has ruled that even the acts which are there in the ninth schedule are open for judicial review. The fifth judgment what Supreme Court gave, it was the backlog vacancies should not violate 50% of the quota. So if there are any backlog vacancies from the previous year, it should not violate the 50% quota for that year. So reservation should not exceed 50%. Now this is judiciary what they did, what they said, and this is what legislature did. They passed 81st Constitutional Amendment Act. Let us read Part 4b, which is nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up in that year in accordance with any provision for reservations made in the clause 4 or clause 4a as a separate class of vacancies. Now what they did is, if you have any backlog vacancies, they will consider it as a separate set of vacancies. So these are the fresh vacancies and these are the backlog vacancies. So that is how the 50% quota will not violate. This will be a separate set of vacancies, backlog vacancies, and these will be a fresh vacancies. The sixth judgment of the sixth ruling of Supreme Court, in that judgment it was the permanent statutory body to look for the under inclusion and over inclusion of the backward classes, and in turn of that, the Government of India, they made National Commission backward classes in 1993 by law of Parliament. So that is how we will constantly see this fight between the judiciary and this fight between the legislature and judiciary and the executives. So next time we are going to start with article number 17 of right to equality under right to equality. Thanks for tuning in.